So the Trump administration is now arguing that machine guns are not protected under the Second Amendment. And essentially they're arguing that the 10th Circuit should reverse a decision which struck down a machine gun possession charge. Now, before we jump into this video, if you want to support the channel for free, please consider subscribing. Also click the notification bell and turn on all notifications because that helps to ensure that YouTube will actually send you these videos. And then also just drop a positive comment down below. That helps to ensure that YouTube will share this video, share this type of 2A content to more people. And this is definitely a video we want to get out to more people. We want to make noise about this issue so that it gets back to Trump, his administration, and his camp so they can correct this error. Now, as I mentioned in the intro, in this video, we're going to be talking about how the Trump DOJ just submitted a very shocking anti-gun argument to the 10th Circuit Court of Appeals. These developments come in the case called U.S. versus Morgan, and we've talked about this case in the past. The Morgan case is a case where a federal judge in Kansas found that machine gun possession charges are unconstitutional in violation of the Second Amendment as it applied to this individual, Mr. Morgan. This Kansas Morgan decision is now being contested by the Trump administration in the 10th Circuit Court of Appeals. In fact, the Trump DOJ just argued to the 10th Circuit that the decision down below should be reversed. They argued that machine guns are not in common use for lawful purposes in today's society and that they are dangerous and unusual items, and as dangerous and unusual items, they can be restricted by the federal government essentially however they want. They also submitted arguments in this case that they also believed the same is true when it comes to short-barreled shotguns and other items, so this is also concerning when you have other cases like the SBR cases and the suppressor cases that are currently making their way through the process that the Trump administration is in control of. But instead, in this new brief submitted by the Trump administration, it shows that Pam Bondi, at the very least, continues to fail in her assignment to get the DOJ and all of the underling attorneys in line when it comes to the Second Amendment. Now, in this case, Mr. Tamori Morgan was charged with 2 counts of possessing a machine gun in violation of 18 U.S.C. section 922-0. Specifically, he was charged with possessing an Anderson, a machine gun, and then also a machine gun conversion device, essentially a Glock switch, and so both of those items were found in his possession. It's the possession of those 2 items that got him convicted of violating federal law, but in response, he moved to dismiss the possession convictions based on the Second Amendment. And on review, the federal court agreed with Mr. Morgan that these possession convictions violate the Second Amendment. The court found that the government relies on Heller to argue that machine guns are not covered by the plain text of the Second Amendment. The Heller language cited by the government is unavailing. First, the government's interpretation of Heller relies exclusively on dicta. Machine guns were not at issue in Heller. Second, the government's interpretation would run directly counter to the essential analysis in Heller. Just as the Fourth Amendment applies to modern searches, the Second Amendment applies to arms that did not exist at the country's founding. So the court there rejected the federal government's arguments that Heller supports a machine gun restriction. The court then looked at the Miller decision by the Supreme Court also, and the court here stated that Miller was devoted to explaining how in the years preceding and immediately following the enactment of the Second Amendment, one of the lawful purposes for which law-abiding citizens possess firearms was for service in the militia. But then the court went on to say that the weapon in question in Miller is different than those being reviewed in this case. Miller dealt with short-barreled shotguns, and here this case deals with machine guns or potential machine guns and then machine gun conversion devices as well. And so therefore the court here found that Miller was unpersuasive because it did not deal with the same items. The judge then reviewed the federal government's historical analogs to see if there was any tradition or history to justify these type of federal restrictions, and the court found that the government did not meet that burden. The judge found that the 2 analogs put forward by the Biden administration did not justify the charges here for mere possession of a machine gun. The judge stated that, to summarize, in this case, the government has not met its burden under Bruen and Rahimi to demonstrate through historical analogs that regulation of weapons at issue in this case are consistent with the nation's history of firearms regulations. Indeed, the government has barely tried to meet that burden, and the Supreme Court has indicated that Bruen in that analysis is not merely a suggestion. After losing at the federal district court level, the government here has now appealed to the 10th Circuit, and that's where this currently sits. And here you have the Trump administration through this new brief arguing that the lower court's decision should be reversed. And they are arguing that the Second Amendment here does not apply when it comes to Mr. Morgan, and that these types of items are not protected under the Second Amendment. Mr. Morgan recently filed his response, and in the beginning of the brief, Mr. Morgan and his attorneys point out that the federal government here is now trying to pull essentially a fast one. They are trying to bring in new arguments on appeal that were not raised in front of the lower court. Also, there are some historical analogs and arguments and pieces of evidence that the federal government is trying to bring in front of the 10th Circuit that they did not bring in the original case. Instead, in front of the district court, the government only put forward two historical arguments. Mr. Morgan's attorney argues that the 10th Circuit should reject and essentially ignore all of these new historical examples since they were not in the record in front of the district court, and all the 10th Circuit is supposed to review is whether or not the lower court committed an error. Well, as I mentioned, the Trump DOJ just filed their response to the 10th Circuit. It appears that these attorneys in the office here of the DOJ are proceeding forward with an anti-Second Amendment position. They may be some Biden holdover attorneys, but also in this brief, signed in this brief, there are names of acting supervisors and United States attorneys which were assigned by President Trump. So at the very least, these Trump assignees failed to properly review the issue of this case and essentially stop these anti-gun arguments from proceeding forward in this lawsuit. Now, in the brief, the Trump administration argues that the district court committed an error when it held that the federal law in question violated the Second Amendment. They argue that machine guns are not in common use for lawful purposes today. To this end, they also argue that the 10th Circuit's review is not limited to just the historical statutes provided by the federal government at the lower court level. Instead, they argue that the 10th Circuit has discretion to now consider new pieces of evidence that the Trump administration presents on appeal. Now, the big statement made in this case that is a horrible look for Trump and AG Bondi in her office is essentially they state that machine guns are unprotected by the Second Amendment. They state that Heller authoritatively held that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, and it explained that this limitation is fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons. The court should not second-guess these conclusions. They go on to state that Morgan wrongfully focuses on whether machine guns are arms. Although machine guns are weapons of offense, that does not mean that they are arms protected by the Second Amendment. So that is a very interesting statement coming from the Trump administration. Pam Bondi in her office and all the underlings within her office, they're arguing that machine guns are not protected arms. They state that Heller makes clear that the Second Amendment right extends only to certain types of weapons. For example, short-barreled shotguns are weapons of offense, yet the Second Amendment does not protect them because they are not typically possessed by law-abiding citizens for lawful purposes. The same is true of machine guns. Now, that again is a shocking statement from Trump and his DOJ. Not only in this brief are they arguing that machine guns are not protected by the Second Amendment, but they're also arguing that the same is true when it comes to things like short-barreled shotguns. And with all of those other looming cases and arguments in the short-barreled rifle cases, in the suppressor challenges, all of these other challenges which are dealing with the similar federal laws, this is not a good look and not a good line of argument when it comes to the Trump administration. They go on to argue that as the opening brief established, machine guns are not typically possessed by law-abiding citizens for lawful purposes, but are instead dangerous and unusual weapons. Morgan's responses cannot overcome that straightforward conclusion. So the Trump DOJ continues to argue in this case that machine guns are dangerous and unusual items and therefore not protected by the Second Amendment. They argue simply that they're not protected arms. So this is not good, and it's not good for AG Bondi. In my opinion, she needs to step in immediately and stop what's going on in this case. Those attorneys that are filing these briefs, they need to at the very least be put on hold. I don't like to call for people to be fired, but clearly there is some sort of disconnect between the higher-ups, AG Bondi, and what she's been directed from President Trump to do through the executive order. There is a clear disconnect from her office and what's going on in some of these field offices in some of the briefs that are being filed in these cases. There are still strong anti-gun arguments coming out of the Trump administration, and this is something that needs to be resolved immediately. Pam Bondi, Kash Patel, all of these individuals need to step in and stop these type of arguments from coming from the Trump administration. If they don't, that would clearly show that this Trump administration is not as pro-2A as they claim to be, and they're going to proceed forward with some of these anti-gun arguments. So that's what's currently going on in this critical machine gun case. Please share this video around and even maybe tag Pam Bondi, Kash Patel, and other officials within the Trump administration so that we can make this case a very high priority so that they can step in and stop what's going on in this lawsuit, because we don't want these type of anti-gun arguments to proceed forward and potentially a bad decision come out of the 10th Circuit because you have the Trump administration arguing for these type of restrictions. So as we get more information, as things develop, I will let you guys know. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.